Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpong, and I am your host. Hello, lovely Saturday afternoon. We are on BWTV. We are live. We are bringing you The Community and the Law. My name is Oreku Frimpong, and I want to ask you those very interesting questions. If you would want to transfer your status from a skilled worker to the marital route, what steps are you going to take? We're bringing you that discussion on the program, The Community and the Law, and we're doing that by courtesy of BWF Solicitors, our trusted partners when it comes to the law. BWF Solicitors is located on the 4th floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters in North London. And we will be riding on their back to bring you all the knowledge, the information, and the updates you need, and also to interact with you as a community. Our resource person this afternoon is Lawyer Charles Asma, also from BWF Solicitors. So gather round, tell the other person to tell the other person that we are live on BWTV, and the program is The Community and the Law.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Hello, once again, and thank you for sticking around. And we are live on DWTV. My name is Oriku Frimpon, and I have the privilege and the honor to welcome you to another edition of the program, The Community and the Lord, is brought to you by BWF Solicitors. This afternoon, I want you to join me on a journey where we looking at step-by-step process for switching from skilled worker visa to spousal visa under family life. So you realize that we're looking at skilled worker route or a visa to come into the UK as a skilled worker. And when you are in, how you switch to a spousal visa under family life. So we'll be looking at skilled worker visa, spousal visa, and what family life is all about. And we're so privileged to have with us Lawyer Charles as my solicitor from BWF Solicitors to do this with us. Now, let me tell you something about BWF Solicitors just before we go on. BWF Solicitors is a law firm that's been in existence for over 20 years. BWF Solicitors is bent on helping the community, especially the Black ethnic minority community, to go on the right hand side of the law. What do I mean by that? Interpretation of the law, representation, helping you to put in your application when it comes to nationality. I'm talking about your visas and immigration matters. When it comes to business development, BWF solicitors would have something to give you. Employment law and all the other bits. When it comes to family, the principal of BWF solicitors is a member of a family board. So he is so well versed in family law here in the UK. And there are a lot of lawyers and members of the family that really understand what it is that we do and they speak your language, meaning that they understand you and help you do that. So I invite you to visit BWF Solicitor, present your cases to them, uh, let them help you navigate that so you can have success with all applications as well. So call them on 0208, sorry, 0208 493 7340, 0208 493 7340. You can also call them on 077 127 61884. 077 127 61884. BWF Solicitors is located on the fourth floor of the Anna House, 214 to 218, Tottenham High Road, Seven Sisters in North London. You can call them on the numbers I have said earlier, and I'm going to repeat that. It's at the bottom of your screen as I speak, 0208 493 7340. They work from Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. Trust BWF Solicitors because, as I keep saying, they are our trusted partners when it comes to the law. Now, so many people have experienced the services of BWF solicitors and they have some feedback to give us. One from Kratos that we have is that Kratos says, excellent service from BWF solicitors. My spouse visa application was successful and Abigail was fantastic throughout the process. Professional, responsive, and very supportive. So I highly recommend BWF solicitors to you. And would want to add my voice to that of Kratos to say, trust BWF solicitors, because when it is that you gave your cases to them to look through and handle for you, they do that with some degree, a very high degree of excellence. BWF solicitors, number again, 0208 493 7340. 0208 493 7340. In emergency situations, you can send a text or send a WhatsApp message to 077 127 61884. 077 127 61884. Or you can visit BWF Solicitors on all the social media platforms at BWF Solicitors. And on a Saturday afternoon when we are live on the Community and the Law, live on BWTV, you can also join us as you are doing today on the platforms, social media platforms, I mean, Facebook and YouTube at BWF Solicitors and at BWTV. So thank you very much, our dear friend that sent us the feedback, Kratos. Thank you for giving us that feedback. Whatever it is that you want to say to us, please let us know so that we can improve upon our services as we move on and also satisfy you better. Well, BWF solicitors, well, we'll continue to say thank you and we'll continue to enjoy your services. What is it that you have for us as far as our nugget is concerned? There's a key lesson we would want to put across here. We are saying from the bosom of BWF solicitors, family life is not always enough. Why are we saying so? Now, it says that the Court of Appeal in the Entry Clearance Officer versus Spence 2026 England and Wales Court of Appeal case 722 has confirmed that Article 8 family life rights do not automatically outweigh serious public protection concerns. Where a tribunal finds continuing safeguarding risks, it must explain why those risks do not make exclusion conducive to the public good. The Court of Appeal in that entry clearance case where it says Spence is saying that Article 8 family life rights do not automatically outweigh serious public protection concerns. Where a tribunal finds continuing safeguarding risks, it must explain why these risks do not make exclusion conducive to the public good. That's a key lesson. And what we are saying is this: strong family ties may support an immigration application, but where serious criminality and public protection concerns remain, rehabilitation evidence and risk assessment become critical. Well, I will be getting Lawyer Smart to help us unravel this later on in the program because the assessment that we're talking about, the risk assessment we're talking about, what goes into that? Rehabilitation evidence, what are we looking for? And this Article 8 thing that we have always relied upon, are we going to have its value kind of reduce and the weight behind it reduce so that we can count on it anymore? What are your thoughts there? We'll be coming back to that. But in the meantime, if you joined us, I just want to welcome you as we're doing our housekeeping and say thank you very much for joining us live on Facebook and YouTube at BWF Solicitors and at BWTV. Let's see who's here. And we welcome you. We go on the platform. Keep your presence felt there in the comment section down below. And as Ade Safo has said, please share when you join. Thank you very much. And that means Ade, you are with us, and we appreciate you for that. If you join us, please let us know. And then you can also send in your text to our WhatsApp and text number 07399208468. 07399208468. Thank you for joining us. You know what? Let's take a message from BWF solicitors, and when we come back, we will go into some discussion and some feedback as well.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Well, thank you for sticking around and thank you for staying. We're live on BWTV, and we're doing this as I keep mentioning, and I want to continue to reiterate that we're doing this courtesy of BWF Solicitors, our trusted partners when it comes to the law. Now, during the week, BWF Solicitors helps us to get educated on matters of the law, and our senior partner has done a video on British citizenship and some of the ramifications around it, some implications of some changes here and there, and what it is that you need to know. It would be done in the Ghanaian language, but when we're done, we'll do a summary of what has been said. Let's watch this.
And then the video may talk about British nationality, naturalization, and our registration. Obi oba kromo ha bia betina bia ade a ɛda n'ani so ne sɛ daakye bia ɔbɛyɛ British citizen na kyerɛ sɛ ɔbɛyɛ application na ɔbɛyɛ British citizen na nsa na obi bɛyɛ British citizen yɛwɔ mmara a aban no ahyehyɛ a yɛfrɛ no the British Nationality Act 1981 saa mmara no ɛno na ɛkyerɛ kwan a ɔbɛfa so na ɔde ayɛ British na nyɛ no nko a yɛwɔ nhyehyɛ bi wɔ hɔ a yɛfrɛ no case workers guidance notes. I no more wasam, I don't know so much so, edidi wasam. You know, a better and the so application I successful. And a good say application now over there. Obey sure, some rana yashishan to be this. New guidance notes are about no diaba a British nationality. So British nationality a registration and naturalization. And she share a your friend conduct and our suban. A be brave, nene, me too many as me and sasso. saa mmiɛnsa no ɛka ɛyɛ den ɛka ɛyɛ sɛ obi akɔ bank akɔgye sika anaasɛ ɔwɔ account wɔ bank na yɛama no overdraft na wayi anaasɛ ɔyi credit card na wade ka anaasɛ ɔnni ɛkwan sɛ ɔbɛyi NHS no na wakɔyi na yɛama no bill na ɔntua home office foɔ sɛ wode ka kɛkɛ a ɛno deɛ ɛnyɛ no na ɔmobɛgyina so deɛ refuse na mmom sɛ wode ka wode bank ka wode credit card foɔ ka wode council tax ka anaa wode NHS foɔ ka na wantua na wanyɛ nhyehyɛe ɛmfa ntua a ɛno deɛ ɔmɛ refuse wɔ application na dɛn na wɔsɛ woyɛ deɛ wɔsɛ woyɛ no sɛ first of all sɛ wode bank ka wode overdraft wode credit card ka wode NHS ka wode council tax ka yɛn nhyehyɛe na sɛ tua nti yɛfrɛ no arrangement nti saa arrangement a wɔyɛ no wobɛgyina so sɛ ɛnɛ yi mene sika a mede bɛtua na mmom sɛ menyɛ sika ɛnkyɛ biara na menya a ebi abosom biara mɛtua £10 anaa £20 anaa £50 na wo ne ɔma yɛ saa nhyehyɛe deɛ nti ɛte saa no sɛ aban ne sɛ wofa suban bi na wode aka bosea na wabobɔbobɔ bosea saa wɔ bank na mmom suban bɔne nti no wontua saa ka na ɔmo so no ɔmo mma wo British nationality yɛmpɛ sɛ obiara te aseɛ no sɛ British nationality no ɛnyɛ ɛhyɛ nti aban ne sɛ ɛnyɛ ɛhyɛ no nti no wobɛyɛ a ɛwɔ sɛ wo ho ɛyɛ korɔgyee wode ka a wotua ɔmo gye council tax a ɔmo ntua anaa obi wɔ hɔ a no ne ku anaa ne yere ne te na waka sɛ ɔno nko ara nɔte na ɛma no 25% discount anaa obi wɔ hɔ yɛ student wɔwie university no anaa wɔwie school no ɔnka nkyerɛ council no ma ɔmo nsesa because students ɛntua council tax obi ɔte fie biara ɔwɔ council tax anaa wɔatwa ntoro akyerɛ council no anaa sɛ wɔndi ne ho ni ɛntua ne credit card anaa sɛ wakɔuse NHS nyɛ wo GP yɛ free obi a wote ha biara wowɔ asetena wo wonni asetena wo wobɛtumi ayi so GP na mmom sɛ GP yɛ referral sɛ kɔ ne yɛnsa wo yareɛ ɛwɔ hospital na wokɔ hospital ɛkɔhu specialist a ɛno ne yɛfrɛ no treatment ɛno yɛfrɛ no secondary treatment ɛno no deɛ sɛ wotua nti ɛno no ɔmobrɛ wo ho receipt anaa invoice a wonni sika a ɛwɔ sɛ wo ne ɔmo hyehyɛ na wotua woantua a nso bɛrefuse wɔ application I hope sɛ wei bɛboa wo bi kɔdodoɔ naa mowɔ ha no mo nyinaa mopɛ sɛ moyɛ British sɛ mopɛ sɛ woyɛ British deɛ a ɔmo sɛ ɛwɔ sɛ ɛka no a wode no wotua anaa wayɛ nhyehyɛ a wotua sɛ wopɛ advice about British citizenship anaa wode ka anaa biribi si wo kwan na wopɛ sɛ wobɛ advice a wobɛtumi afrɛ BWF solicitors about British nationality anaa registration anaa naturalization yɛ numbers na ɛdi so.
So, Lawyer Bernard Owusu was talking about what impact loans, council tax, and NHS debt would have on your application as a British national. And what he was saying was that if you are into debt and you have no arrangement to make the payment, if you owe the NHS, and when you have used secondary medical treatment or medical care, and you have not made any arrangement to pay your invoice, you could be denied British nationality when you put in an application. And then again, he's talking about council tax. People have gone for council tax discounts as students, and people living alone in properties. They have completed their education and they have not declared to the Home Office that they are no more students. And he mentioned that students do not pay council tax. So when you are no more a student, you should declare and make the government know that you do not qualify for that rebate or discount anymore. Now, when you don't do that and it's time for you to put in an application for your British citizenship, you could be denied and your application will be refused, so to speak. So people should be aware. If you need any immigration advice, any advice on British and nationality issues, you can contact BWF solicitors. The numbers he showed us in the video and on the screen: 0208 493 734 493 7340 or 077 127 61884 077 127 61884. BWF solicitors are trusted partners when it comes to the law. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. Please contact them because you can be sure that they will be able to help you. In the next moment, I will be introducing my resource person and guest this afternoon on the program, The Community and the Law. And Lawyer Charles Osman will help us understand and go through the process, step by step process, where we would want to switch from a skilled worker route to the family life route where we're coming in as a partner or a spouse. That is our discussion for this afternoon, right after this.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340 or our emergency line is 07712 761 884.
Well, I mentioned earlier on, before we went on the break, that we'll be welcoming onto the program our resource person and guest for this afternoon. I'm talking about Lawyer Charles Asma from the Stables, our BWF solicitors. Lawyer Asma, good afternoon.
Good afternoon, Brakuku.
How are you, sir?
Very well. How are you?
Happy birthday, though belated.
Thank you. Thank you so much.
Well, listeners, viewers, and family members out there, it was Lawyer Asma's birthday earlier in the week. And let me see if I can find my voice. We need to sing to him. We need to sing for him happy birthday. May God bless you. May God enlarge your coast. May God give you everything you wish for. May you prosper and go higher and higher and higher. We confer on you all the blessings.
Amen.
Well, this afternoon, we are going to look at, in fact, there are two major things we want to look at. One is what our topic is, that is the step by step process for switching from skilled worker visa to spousal visa under family life. We'll be looking at that as our main discussion. But earlier on, we looked at this Article 8 thing that's coming up, and there's a key lesson you would want to bring out to us. The Court of Appeal case CIV 722, which confirmed that Article 8 family life rights do not automatically outweigh serious public protection concerns, where tribunal finds continuing safeguarding risks. It must explain why those risks do not make exclusion conducive to the public good. Now, the question I'm asking is, the Article 8 right, has it lost its weight that it may not be able to be a pillar for people to hide behind anymore? What's happening?
Thank you very much. Now, before we delve into that, I just want to provide a context.
Mhm.
And with the context to provide, I also want to create an analogy
Okay.
for us to understand why the court has taken this position. We have what we call confidentiality, and we also have disclosure.
Okay.
Disclosure is good, confidentiality is good. Disclosure means you must let others know. Confidentiality means you must not let others know. So, question: when there's disclosure and there's confidentiality, and the two are opposite, aren't they?
Yeah, they are.
Where do they meet? Disclosure and confidentiality. Where is the point of intersection or point of interest? Somebody will tell you that
Mhm.
by disclosing this, it's wrong. Somebody would tell you that by not disclosing this, it's wrong. So where is it allowed? So even with our work as solicitors or lawyers, confidentiality is very, very key. However, where disclosure is required by law, confidentiality will have to give way.
Okay.
Where disclosure is required by way of duty, confidentiality must give way. Both are important, and therefore, depending on the context, one will outweigh the other. Now, example will be that court has asked you to provide certain information about a client. Who has asked for this? Court, right? In the
Yeah.
best interest of the situation. At the
Okay.
same time, the rules say that you must keep your client's information in confidence. So confidentiality is important. But where it is required by law, then you can't say that I have duty to keep a secret, so I will let you know. That is that point. Now
Okay.
we go to court, and the court says that when applying for visa to enter the UK on the basis of your family life, because of family life, which is an entrenched right within the European Convention on Human Rights and the Human Rights Act 1998, specifically Article 8, says that you have right to family life. And so nobody can take that away from you. That is a right, isn't it?
Yeah.
Now, the law also says that if your behavior is not compatible with the public good, then we cannot keep you among the public. That is also some others. So if the law says that because of your Article 8 right, we should give you the liberty to mingle and misbehave. then that is also going to affect the right of other people, isn't it?
Yeah.
So where do we draw the line to protect the right of others and to also protect the individual right? And that is why I started by saying that where confidentiality and disclosure are at odds with each other, if it is required by law, confidentiality must give way to disclosure. And so where public interests and human rights are at odds with each other, then public interests must give way to human rights. Is that clear?
Yeah. Now, the ruling mentions safeguarding risks. And then the key lesson that you provided us was that if there are serious criminality and public protection concerns, so to speak, rehabilitation evidence and risk assessments become critical. So then you will be taking through some assessments to determine whether you are fit to be in the community. Is that what it is pointing out to?
That is one, because there's always room for assessing mitigation. So if it is obvious that the person has rehabilitated and the public interest element is clear and it's favorable to the public,
Right.
then the person's human right will take preeminence. So the point is this: some people might have gone through the assessment and all that, but it still shows that it is not enough for them to be allowed back into the community.
Mm-hmm.
Then, regardless of how much human right they possess,
Well, we are having a few challenges here and there, but then lawyer Charles as well was taking us through the um, key lesson that family life is always not enough. And we're looking at that in the context of the public good. Now, he is saying and trying to let us in on the fact that um, confidentiality and the statutory bits, when they come into play, full disclosure definitely would override the bit of confidentiality because of the public good. He was explaining all those bits. And the other question, if we re-establish the connection, is what I would be asking us: what really is the public good? Are we talking about just safety? Are we talking about safety of who? Children, women, um, the young, the old, who would really have to be protected when it comes to the public good. Remember, we're saying that the Court of Appeal in the Entry Clearance Officer versus Spence 2026 case, EWC, that is England and Wales Court of Appeal case 722, has confirmed that Article 8 family life rights do not automatically outweigh serious public protection concerns. We are saying where a tribunal finds continuing safeguarding risks, it must explain why those risks do not make exclusion conducive to the public good. And the key lesson here is that family ties, strong family ties, may support an immigration matter, but where serious criminality and public protection concerns remain, rehabilitation evidence and risk assessment become critical. That's what we're on there. The last one, yes, you were on the point, and as part of it, the public good, who is being protected here?
so with the public good, we are looking at full protection for the public,
Okay, so everybody is included.
and everybody is included. So somebody who has been convicted of a serious criminal offense
Mhm.
has been sentenced into prison, stayed in for 12 months or more,
Mhm.
and has been deported. Why was the person deported? Because their behavior was not consistent with the public good. So the person was deported. And the
Okay.
person now says that I have my family life in the UK, so I have to be allowed back. The court is saying that yes, you have your human life or Article 8 right,
Okay.
family life right in the UK.
Mhm.
However, the public good duty that you have for others outweighs your personal human right. And so, depending on the threshold where it is assessed that the person has not refined enough to be allowed back into the community, their human right will not be entertained.
Okay. Well, thank you for this. And in situations where the assessment is made, the determination is made that in the interest of public good, this person may not be or may not be allowed in. Let me put it that way. Is there any remedy, or when that determination is made, that ends the story?
The only remedy may be because when it comes to these serious matters, the application may be refused and sometimes certified.
Mhm.
Certified means that they may say that they claim that your human right outweighs blah 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 may not be founded, or the visa will be refused and you'll be given right of appeal. Then you go to court for the court to determine whether your your duty to the public should be should be compromised with your right to family life. If the judge determines that that is so, then of course your family life will prevail. But where there's no right of appeal granted, you can go for judicial review. So the remedy is always there. But if it is obvious that there's clear indication that your behavior, your past, your criminal history, the seriousness of it, and impact to the community are such that the judge will not deem it fit to allow you back into the community or to return to the UK, then the judge will always side with the Home Office.
Thank you very much. And it reminds me of the saying that a stitch in time saves nine. Listen, do what you have to do, stay within the law. And then, if you would have to depend on family life, which is Article 8, it will be enough to protect you one way or the other. Other than that, if the British society says that you are a danger to the public good, forget about it. It may not be working for you, as we are referring to Article 8. It's a community and the law. And as I said, Loyasma has an interesting discussion to go into with us. Now, we're going to look at step-by-step process for switching from skilled worker visa to spousal visa under family life. Lasma, I will pose the broad question. Why would somebody switch from that end to the other end under family life? What are the circumstances that would make that necessary? And then a skilled worker and somebody with a family visa under partner route, what is the difference? Now we are before you with our notepads and pens ready. We're ready for the lesson.
Right. Thank you very much. Will you be not that so that we've discussed the nugget, but I'm not sure whether you'll be letting the community know the
Yeah,
the question.
I'll pose the question. Yeah.
All right.
Okay.
Okay.
I think having mentioned that, let me still pose it. Hold on. Let me test your knowledge. So look at this scenario. Bob joined his parents in the UK as an EU family member. Now, upon arrival, he was granted 5 years pre-settled status. After 2 years in the UK, he was convicted for sexual offense, sentenced, and then deported from the UK. In 2024, Bob and his wife had a baby. Bob's wife is a British national, and by that, the child was issued with a British passport, which made the child a British citizen automatically, as it's were. In 2025, he applied for a spousal visa to join his wife and the child, but he was refused. The reason the Home Office gave was that because he was deported from the UK for a serious offense, the public interest overrides his family life right under Article 8 of the European Convention on Human Rights. Okay, now look at it again. I have a child who is British. Because I was convicted of a sexual offense, I was sentenced and deported from the UK. But then I have my child, my wife, both British, living in the UK. So even though you've deported me, you sent me back to my country, I need to come and see my family. Family is important. You can't separate me from my child. So, okay, then I'm going to appeal. He now wishes to appeal the decision, as I said. Please, let's advise Bob. Are we going to say that this appeal will be dismissed because human rights do not override public interest of excluding serious offenders from the UK? The second option I gave is the appeal will be dismissed because he did not meet the requirements for his application. The third point is the appeal will be allowed because he has had a child and wife in the UK. Then the fourth option is the appeal will be allowed because he has never broken his deportation conditions. So, Bob, I'm throwing this to my viewers and the community. We'll come back. Whatever answer they give, I will throw it at Lawyer Asma again. I knew he was eager to answer it, but Lawyer Asma, just hold your fire. Hold fire up there. Put it to one side. I'll come back to that. So you give us the right answer. But let me test my viewers and listeners in the community before we do that. Bob was in the UK. He committed an offense, was sentenced, and deported. He wants to join the wife and the child, but the government says, no way, you're not coming. What advice would you give to him? What would you say to him if he appeals? We'll come back to it. But last man, thank you very much. A stitching time to say saves 9. So I've saved the 9. But let's go Sankofa now and back to our topic. The step-by-step process. You oftentimes take us through step 1, step 2, step 3, do this, do that. If you do A, this is what happens. Do B, what happens. Today we want another dose of that. But this time, we're looking at switching from skilled worker visa to a spousal one under the family route. Let's go on it.
Okay. So, yes, we are looking at switching from one end to another.
That's right.
The question somebody would want to ask is switching from where? Law allows us to switch from one category of immigration visa to another.
Okay.
It's a matter of choice.
Okay.
So you can be a student and you decide to switch to skilled worker visa. You can be a skilled worker and you decide to switch to your parents or your children if you qualify, family life. You can be on the human family life and you decide to switch to skilled worker. It's a matter of choice. And each choice will determine what you seek to get. In terms of whether you be granted, refused, and so on and so forth, you have to meet the specific requirement of that visa application. So, somebody might have entered the UK as a skilled worker. Before they came to the UK as a skilled worker, they had their parents in the UK from EU, for example.
Okay.
So once they entered the UK, they decided that now that I'm in, I have immigration status. And because I have immigration status, I want to use that status to switch to another status. So the person can switch from skilled worker to EU status as a family member of an EU national if they qualify. Somebody will also say that I came in as a skilled worker, I came in single, once in the UK, I started a relationship, the relationship is gone far. Myself and my partner are now married. We are living together as husband and wife. I want to switch from being a worker to being a family member of somebody who is British citizen or somebody who has indefinite or somebody who is an EU national with status in the UK. You are at liberty to do that. It's a matter of choice. It's just like saying that I ordered this particular food or dish on the menu, and as soon as the food is served, I started eating. And I realized that, you know what, I want to change it to another food. If I ask for them to serve me another meal, will they say no? Or they will go ahead and serve me if I can pay? Which one?
Yeah, if you can pay, they will. And sometimes, for the reason you give, they may change the meal for you.
Exactly. And therefore, it's a matter of appetite at the time.
Okay.
So if your appetite at the time has changed and you can meet the requirement for the request that you seek, the law will allow you to convert from skilled worker visa to family life visa, convert from student to family life visa, convert from any other category provided you meet the requirement, which is provided you can afford the new request.
Okay.
And today, our job now is to have a conversation the way the caseworker will have it during the visa application consideration.
Okay.
What are the step-by-step processes that the caseworker will go through to assess the application for somebody who is switching from student visa to, for example, family life visa? So the question here is, what do we mean by family life visa? Family life visa is a visa under Human Right, Article 8, where the person has a spouse, and the spouse is a qualifying partner or a qualifying spouse. So, under Section 117D of the Nationality, Immigration, and Asylum Act 2002,
Mm-hmm.
excuse me, the law looks at who a qualifying child is and who a qualifying partner is. Today's conversation is not about children, it's about partners. So we are now looking at a qualifying partner.
Okay.
A qualifying partner is a spouse who is British
Okay.
or a spouse who has indefinite leave to remain in the UK
Mm-hmm.
or a spouse who has EU citizenship or EU passport with 5 years or with indefinite status in the UK. These are qualifying partners
Okay.
under human rights. You realize I didn't mention somebody who is a partner who is a student. I didn't mention a partner who has post-study work visa. And I didn't mention a partner who has a skilled work visa. Because those people are not human rights partners.
Okay.
They are partners, but not partners under Article 8.
Right.
And that is why when somebody makes an application to switch to a partner who is a skilled worker, the person cannot argue human rights because this application is not a human rights
Not a human rights
application.
application.
It says a visa for a skilled worker dependent is purely under work rights, not human rights.
Okay.
So let's draw the distinction because
That distinction.
sometimes people are making application and say, "Oh, lawyer, I have remarried, and my new partner has skilled work visa, and the visa will expire in 2028. So I want to switch from being a partner, skilled worker partner, to another skilled worker partner because I have now begun a new relationship or I have married. That is not human rights. That is an application under appendix skilled worker partner. And so if you don't meet the requirement under skilled work partner applications, you'll be refused.
Okay.
What we are talking about is human rights. And that is why sometimes when people say that, oh, I want to apply as a dependent skilled worker, can't I argue my human right? You cannot argue human right because this is not a human right application. The conversation we are having is human right application. And therefore, that partner must be a human right partner. A human right partner will be a British citizen, an indefinite leave to remain holder, or an EU passport holder with 5 years or with indefinite. So we've drawn the distinction clearer. So first off, the caseworker will want to see whether the person meets the requirement for the application under Appendix FM. And then for the application must be Appendix FM application, not Appendix skilled worker application or Appendix student application or Appendix EU application. So that is the first point that we have to establish for the caseworker.
Okay.
Having scored that point, that my partner is a qualifying partner, the next stage is there a subsisting and genuine relationship between you and your partner? And that is paragraph RWP 6.1 and 6.2 of Appendix Relationship with a Partner. Appendix Relationship with a Partner cuts across. Whether it's a skilled work partner or human right partner, it cuts across. But because the person is applying as a spouse or a partner, that paragraph is relevant for the caseworker. So the caseworker will want to know whether your relationship with your qualifying partner is genuine and it is subsistent. If it is genuine, it means you've gone through the formalities to establish the relationship.
Okay.
If it's marriage, you married under valid immigration law, valid marriage law for that country. If you married in the UK, you followed UK marriage law. If you married in your country, be it Ghana, Nigeria, Jamaica, America, wherever it is that you come from, you followed that country's marriage laws to marry. And so if the person married by proxy, where the person was represented by family members, the person must prove that in that country, marriage by representation is allowed. If marriage by representation is not allowed in that country, and you do that because some people are doing it because they come from other different countries, your marriage will not be valid because there's no law in your country that will support the type of marriage you have contracted.
Okay.
So the first point is the marriage valid? That is the genuineness of the marriage. Is it valid in your country? There's case law to support the claim that if the marriage is valid in that country and the person followed that process to marry and it is cleared as valid, the UK must accept it as valid.
Okay.
But that is only showing the genuineness of the relationship. But the law so genuineness of the relationship is paragraph RWP 6.1. But the caseworker will also look at paragraph RWP 6.2. What does 6.2 say? 6.2 says that in addition to the genuineness of the relationship, you must show that the relationship is ongoing. How do you show that the relationship is ongoing? Where you can prove that you are having your family life as everybody will have it. So whether you are with a person or you are not with a person, you must prove that your relationship is ongoing as married couple will have it. So how do married couple behave? But again, we go to the second part. The first point we established. We established that genuineness of the relationship is based on marriage, isn't it?
Yeah.
But somebody will also ask, what if I'm not married to the person, but I am living with the person, or not even living with the person? Is relationship enough? Yes. The law says that if you are not married and you are living together as unmarried couple or partners, then you must show 2 years relationship. 2 years. So the 2 years relationship is either living together or not living together. But Bakoku, you agree with me that it is easy to prove that your relationship is ongoing if you are living together
Even
than to
together.
prove if you are not living together.
Yeah, because obviously you would have certain bills that may be in both of your names because you may be paying. There is proximity, and you do things together that you can evidence. So it's quite easier to do. Yes.
Another question somebody will ask is, lawyer, does it mean that if we are not living together, I cannot apply as a spouse? The answer is simple. You can still apply as a spouse, just that you need more evidence to prove that the relationship is
Relationship is subsistent.
ongoing or subsisting. So, how do you prove that the relationship is subsisting? One, and we are going to keep it practical as
Okay.
possible.
Okay.
Brankoku, you and I are together.
Mhm.
Today, I am Chelsea, and you are Kweku. Today, I'm not Charles, I'm Chelsea. Now, yes, we are together.
Mhm.
We are together as husband and wife, and here, opposite sex. Sometimes it can also be the same sex by operation of law. If you
Yeah.
go the same sex, you still have to prove it. But I'm choosing Kweku and Chelsea for ease of discussion.
Yeah.
Now, so you and I are together. How do we prove to anybody that we are together? If we are indeed together, what will be going on between us in terms of common human behavior between friends? If we are friends, to the extent
Mhm.
that we are in a relationship and we are spouses, what will be that one thing that you want to see happening? We have to be talking, right?
Consummating, have children, maybe.
What? Childbirth is not compulsory.
It's not compulsory, yeah. But at least
Childbirth
you
is not
that
compulsory.
should
So
be an
that
evidence that you have consummated your relationship with it.
not necessarily. Childbirth, what about those people who have struggled to have children? Are we going to punish them because they don't have children? So childbirth is not
It's not
compulsory, and
compulsory.
the law
Okay.
doesn't talk about children. But the law talk about ongoing communication.
Okay.
Because even friends talk, right?
Yeah, they do.
So what about people who are in a relationship? You have to be talking there.
They have to be
So we
talking
must have
daily.
the ongoing communication. And what are you going to use to prove that you and your partner are living together and you are talking to each other, or you are engaging, you are having ongoing life? These days, in those days, some people will provide birthday cards.
Hmm.
But today, people don't provide birthday cards. They provide everyday conversation
Everyday
by
conversation. So
WhatsApp, isn't it?
your call logs, your WhatsApp messages that you have exchanged, the text
Exactly.
messages, the electronic cards you may have exchanged between the two of you, and of course the frequency of the communication would also be handy and very relevant.
Very good. And I like what you said that the frequency of the communication.
Yeah.
Because if the communication is not frequent, you know that the caseworker may think that, what is going on?
Hmm.
And so imagine you are not living together and the communication is also not frequent between the two of you. Then it will be difficult to prove that your relationship is ongoing.
Ongoing, yeah.
So the reason why we ask that people should add their communication history is simply to show that there's ongoing engagement between you and your partner.
Okay.
The law does not say provide communication, but communication is able to provide common sense understanding to the caseworker that the relationship is
It's
still
ongoing.
subsisting. Right.
Okay.
It's not dead, it's still ongoing. The next thing is help you offer each other.
Okay.
So you will be giving me money. Somebody will say, why would the man be giving the woman money? What about the woman giving the man money? Yes. So the woman can also give the man money. So if you are in the UK and you want to bring your husband from abroad, you, the woman, can also send your husband money. If your husband is well to do abroad, they can also send you money. So it's not always you sending money home or to your partner who is abroad. Your partner who is abroad can also send money to you. That's one case I did where they wanted to prove the ongoing relationship. It was a skilled worker spouse. And the bank statement of the lady could show that the man transferred money to her to her account, a UK account from Ghana. So the money was transferred by international money transfer process into her bank account. What did she use the money for? She had entered the UK, and the employer said that she need to get a car to be able to drive so that they can give her job to do because the care work required driving. And she didn't have money to buy a car. So the husband transferred money to her. And we're able to rely on that to prove that the relationship is ongoing. And that even whilst in the UK, the husband still looks after her. And that is why he sent money for XYZ. And I was able to prove a point to make a case for the husband application to be granted.
Okay.
So the conversation we are having is whether you are in the UK, applying from the UK, or you're applying from abroad. It doesn't really matter. The step-by-step processes are the same. So first, we have ticked the box for relationship. Two, we are ticking the box for ongoing aspect of the relationship. So money transfer, if you are in the UK, you are not going to have money transfer. So you can only have maybe money sent to your husband or sent to your wife's bank account because they will use it to pay bills at home.
All right.
Somebody will say, what if I send money so significant into my husband or my wife's account? Would that be a red flag? Question. If you are in the UK together, why will you send £5,000 or £10,000 to your wife or husband if there's no justification?
Yeah.
Unless you're able to say that my husband transferred this money to me, or I transferred this money to my husband because we are building an investment portfolio somewhere, and the transaction had to go through my husband's account.
Your husband's account. Okay.
If that is the case, then you also have to go on to prove that that transaction actually took place, the so-called investment
It's taking
transaction.
place. Okay.
Exactly. Otherwise,
So
you
then the
can only
money
be
doesn't
telling
have
a
to
story.
move from one account to the other and sit there. It has to move on to do what it is that you say it is meant to do.
Very good. Otherwise, they will think that, hang on, why will a wife be paying a husband? Or why will a wife be transferring 10,000 to the husband account if not for a good reason? So you have to justify that huge payment or transfer into your wife or husband account. But if it is general bills, then that's fine. £500 for rent, £1,000 for rent, £1,500 for deposit, £700 to buy things online because my wife has that online account, and so I transfer the money to her or she transferred to me to be able to make the payment. That's acceptable. And so any trace of payment will depend on the purpose of it for it to make sense.
Okay.
So let's bear that in mind as well. What else would the caseworker be looking at to prove that the relationship is genuine, the relationship is ongoing? The caseworker want to see whether there's photographic evidence of life between the two of
The
you.
two of them.
And that is why we say add pictures, family pictures.
Okay.
The law does not care about pictures, but human life need to be remembered.
Okay.
And so the photos will show how we have been living our lives, right?
Yep.
And that is why you need the photos to support your claim that your relationship is ongoing. So when your lawyer says that bring money transfer or bank transfer, bring WhatsApp chats or call logs, bring photos, it's for a good reason. and that is what we are looking at. Right.
Now, these
So,
photos, let's bring it very, very down to our level. If I oftentimes take pictures of my wife and put them on my phone, or my partner, put them on my phone, and then comparing that to some selfies we take, and also going out on evening dates, going sightseeing, and all those things, and we take those pictures. Would the ones we are in together be stronger in evidence than the ones I take of that person and I keep?
okay. So you are making your application, right? You
Mhm.
are switching from skilled work visa to family life as a partner
Yeah.
because your partner is British. So again, the conversation we are having, you are switching to me, Chelsea. You are switching to me because I am British and you are a skilled worker and you want to migrate by choice from skilled work visa to family life visa. We are married, so we have proven, but we have to prove the relationship is ongoing. You have your personal pictures, don't you? I have my personal pictures.
Yeah.
The question is, when was that taken? You cannot say that you took those pictures when I met you. It's also possible that you had your own pictures before I
Mhm.
met you. So how will you then say that, yeah, your individual picture is evidence that our relationship is ongoing?
Mhm. It would be a bit difficult.
And so the one that caseworker will be convinced about will be the one that will show both of us. And that is what we call couple or family photos.
Okay.
Family photos.
Okay.
So family photos are more important than individual photos. Because individual photos could be even before we met. But family photos can only be after we have met and the fact that it is still ongoing.
Okay.
And again, so to answer your question, it's better to rely on family photos as a family. If you have children, with your children. If you don't have children, the two of you, than just individually.
Okay. All right.
And again, somebody will ask, what sort of photos? Is it one photo, two photos, or how many? There's no formula as to how many. It's up to you. The more, the better. But again, the more in what context? Imagine, you see what I'm wearing?
Yeah.
If all my photos I have in the world show me wearing this, what does that mean?
You took them in one day.
That is one reason. What's the other reason?
You
I have only one dress or cloth or attire.
Yes, but what does that prove? If I've
I'm
only
coming
one
to
one
something.
shirt.
I'm coming to something.
Okay.
So if I have this all the time, you are not going to tell me because it's not your business, but a lot will go in your mind that, wow,
Obviously, yeah.
it's got only one. Or even the two of us, if we always appear in what we are wearing today, viewers and listeners will be wondering, why don't they change their wardrobe?
Mm-hmm.
Or they don't go home from the studio. So every week they are there.
Yeah. Right.
That is
Like
not law. This is where sociology
that's
comes
it.
in.
Yeah. Obviously.
Yeah. So when people present pictures, I tell them that let's analyze your pictures. Are you telling me that these clothes that the two of you are wearing are the ones you have? Because all the 10 pictures you've given me show the same
The
clothes.
same thing. Yeah.
All the 10 pictures you've given me show that you are at McDonald's. That means, as for the two of you, all that you know in the world is McDonald's.
They don't tend to be too romantic. They just want to go to McDonald's.
You don't even have a home then. So what am I saying? What I'm saying that there should be a variety of photos to tell a story.
Definitely. Definitely.
So I tell people that your photos must be a reflection of your casual life or informal life and your formal life. Your informal life will be being at home, being out and about with your man or woman.
Mm-hmm.
So you see you wearing your jacket. We say that, wow, this one was winter. We took it during winter. We took it during COVID time. We took it, and we see you also wearing your summer wear. This is summer time. Having something, we see you having something at different places, locations. Some are formal, to the extent that, for example, formal could be attending events, weddings, church, funerals, and all those events. These are formal stuff. So when you are looking at the history of your life as a couple or together, you have to make it tell that story well. And I believe this conversation will help people to understand what sort of photos are required. Informal photos and formal photos. Informal dresses and formal dresses across the board. So you pick from. And again, your marriage photos. At the time you are marrying, if you took photos. If you didn't take photo, but you must have family photos together. Then we move on to the next stage.
Yes.
The caseworker will also want to understand that in addition to the relationship and the immigration status and the qualifying partner status, the person meets the financial requirement. And the financial requirement is 29,000 a year. 29,000 a year. Either coming from both of you combined or coming from one of you. So if it is coming from you as the main applicant, then your salary. So it's possible that the skilled worker is working, earning about 30,000. The skilled worker can use his or her own salary. Or the skilled worker is working, but the salary is 20,000 or 23,000. And the husband is also working, the salary is 30,000. So then they can agree, you know what? My husband, who is the British citizen or the indefinite leave to remain status person, is the one who is going to sponsor the finance. So I'm not going to bother about mine. But what we are saying is that the two of you decide whose income is enough to cover the 29,000 we need. If it is not enough for both of you or from both of you, they have to combine to get 29,000. That is that point. What about somebody who doesn't work? The skilled worker earns 23,000. The husband or the wife who is British and going to sponsor that person doesn't work, but is self-employed. In this case, the self-employed income must show profit of 29,000 or more. Profit. That means once you file your self-assessment tax to HMRC, you declare your profit. Profit means all the money that came to you as a self-employed person minus all your expenses that you pay about the business. Whatever is left is what you are going to pay tax on. So it is what you are going to pay tax on that you need to show for immigration application for yourself or for your wife or husband. So that is
let me get this small clarification here, if you would mind. We're talking about combined income. Now, the skilled worker may earn, say, 20,000, and we need that extra 9,000 that may have or can come from the spouse. Now, the spouse is self-employed. Does it mean that if the spouse is able to declare a profit of 9,000, that will be enough to support the application when they put the two incomes together?
The answer is yes.
Okay.
Yes, but the more the better.
Okay.
Yeah. So minimum is 29. So, but the more the better, because if your husband is self-employed, why would they earn profit of exactly what you need for your immigration application?
Okay.
So sociology aspect of it will mean that if this is natural, then it wouldn't just be a coincidence that the difference is what the husband has.
Okay.
So the husband may have 11,000.
Yeah. If you just joined us, the topic we have been discussed this afternoon is the step by step process to switch from a skilled worker visa to a partner visa. And then we are looking at the what the law says and the common sense approach to it, where it is that, as lawyer just mentioned, the sociology aspect of the whole thing. If you have any questions, you can send them to our text line 07399208846. It's either on WhatsApp or text, or you can leave them in the comment section down below on Facebook and YouTube at BWF Solicitors and at BWTV. We're doing this by courtesy of BWF Solicitors and Trusted Partners when it comes to the law. They are on the fourth floor of the other house, 214 to 218 Tottenham High Road, Seven Sisters in North London. Call them on 0208 493 7340 0208 493 7340. As I said, and as you would have known, lawyer Charles Asma from BWF Solicitors is here with us, and he's taking us gradually through that. Lawyer, we've looked at who is being considered here, the financial threshold, the subsisting relationship element that we need to prove. What else would the caseworker be looking for? Yeah, remember we live on BWTV, and the program is the community and the law, the step-by-step process for switching from a skilled worker route to the partner route. Let's take a quick break, and when we come back, we'll get lawyer Charles Asma back on.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Okay, so whilst we still wait to join that, remember I gave you the nugget and the scenario question. Let me remind you of that because very soon I'll be asking you to give me the answers to that. Family life is always not enough. That's what we said. The Court of Appeal in the Entry Clearance Officer versus Spence 2026, England and Wales Court of Appeal case 722 confirmed that Article 8 family life rights do not automatically outweigh serious public protection concerns. Where tribunal finds continuing safeguarding risks, it must explain why those risks do not make exclusion conducive to the public good. And the key lesson we had there was that a strong family ties may support an immigration application, but where uh, serious criminality and public protection concerns remain, rehabilitation evidence and risk assessment become critical. And we're talking about Bob that was in this country, met the wife, they had a baby. But during the time that he was here, he was convicted of sexual offense, sentenced, and then deported to his home country. In 2025, he applied for a spousal visa to join his wife and a child, but he was refused. The reason for the refusal was that he was deported from the UK for a serious offense. The public interest overrides his family life right under Article 8 of the European Convention on Human Rights. So we're asking what Bob's appeal could give him. And we're saying that the appeal will be dismissed because human rights do not override public interest of excluding serious offenders from the UK. That was one option. The second option we said was that the appeal will be dismissed because he did not meet the requirements for his application. The third one, we said the appeal will be allowed because he has a child and wife in the UK. And the fourth option, today we gave you a bigger array or a wider array, so to speak, of choices. The appeal will be allowed because he has never broken his deportation conditions. What do you think his appeal will yield? Think of that. But let me go back to Lawyer Charles Asma and we conclude our discussion. Yeah, Lawyer Asma, just before we went on a break, what I was saying that we've looked at some scenarios. We looked at who would be having that criteria or the qualified person, so to qualified partner. That's the term. Then we looked at the financial requirements, the threshold, which is the £29,000, which could be a combined income of both partners. And then we've looked at the subsisting relationship. Is there any other thing the caseworker from the Home Office will be looking at?
Yes. Yes. So the caseworker would also want to know whether the person meets the English language requirement.
Okay.
And the English language requirement is that applying from the UK as a partner of a partner, Appendix FM partner, you have to show that the English language requirement is met, and that is A2, because you are in the UK. If you are applying from abroad, it's A1. So that is the difference. If the person, the skilled worker migrant who is switching to family life because the husband is British or has indefinite, then if the skilled worker already met the English language requirement with ECTIS or foreign degree, then that is fine. That can be used again. Somebody will say, what if I use IELTS for work visas? The immigration rule, English language requirement for Appendix FM spouse is speaking and listening. The work is for speaking, listening, reading, and writing. Somebody will say, well, if I have passed speaking, listening, reading, and writing, why can't I use that result to prove my speaking and listening? I do tell people that if you have written that and passed, then you might as well take the A2 so that it will be easier. So for the English language, it's A2, speaking and listening. And you have to have it as part of your evidence. Then, of course, accommodation. You and your husband, so you have to be living together. But as part of the relationship, we also said that your photos, the communication or that in addition, there must be evidence that you are living together. That is for those who are living together. In this case, you have to show living together by proving having a proof of address that point to the same address. So when you look at the proof of addresses of the husband and proof of addresses of the wife, the address must be the same.
Mhm.
You cannot say that my husband lives, we will live together in London, but my husband works in Manchester, and because of that, his address is in Manchester. Then you cannot prove subsisting relationship. Because if it's a family home, it's a family home. Both of you must be located or traced to that family home. So let's bear that in mind. And because the caseworker will be looking at that as part of the step-by-step processes. Now, we've gone through all the key things that we would normally go through as far as the caseworker's assessment is concerned. And if you're able to do that,
Mhm.
the law says that the person who is applying under Appendix FM as a partner. And as a partner, we are looking at the eligibility requirement, specifically relationship. And the relationship, so we are looking at paragraph E, L, that's L means leave, and T means to, and R means remain. So eligibility for leave to remain application for partner 1.1. So we say paragraph E, L, T, R, P 1.1 of Appendix FM to the immigration rules. And that is what you have to show because you are applying to remain in the UK with your partner who is a qualifying partner. And we define the qualifying partner under section 117D, 1B of the Nationality, Immigration and Asylum Act of 2002 as a partner who is British, or a partner who has indefinite, or a partner who has EU passport with 5 years pre-settled or indefinitely to remain settled. So these are the things the caseworker will be looking at. Can the caseworker refuse the application?
Yeah.
If the caseworker refuses the application, then we can say that they did not consider all the evidence we provided fully.
Okay.
If you have done your job properly by providing all the things that you need to provide to meet the requirement, then it is for the caseworker to follow the law. If the caseworker doesn't follow the law properly to apply it to your case and you are refused, you can go to court to appeal under the in court against the caseworker or against the Secretary of State.
So in this situation where people are switching, does it come with the automatically appeal right? The right of appeal. So
But oh yes, this one will have right of appeal. One thing that we have to also mention here is that most skilled workers might have entered the UK, and this is presumed. So let me put it correctly. It's presumed that most skilled workers would have entered the UK with their partners. So if you switching from skilled work to family life Appendix FM came with your spouse, then you have to show that you and your spouse divorced before starting a new relationship and getting married.
Oh, okay.
And you also have to show that you have informed the Home Office about the separation or breakdown of that first relationship before the new partner made an application for a visa for you or for that person. If that is not done, the person's application will be refused because the spouse if, for example, you are the skilled worker, you came with your partner, you didn't tell the Home Office that your relationship is broken down, and you are applying under me, a British citizen or somebody with indefinite, you are going to be refused the visa because you didn't tell the Home Office that your first relationship broke down before starting another with me for me to sponsor you.
Oh, okay.
And the same way, if I am the one or the skilled worker switching to you, my husband or wife, the British citizen or indefinite person, I have to still show that if I came with a partner, is broken before. You have to tell the Home Office. The question is, when do you tell the Home Office? You tell the Home Office immediately you became aware that the relationship is broken down. Sometimes people will say that, oh, lawyer, I didn't know that I needed to have told the Home Office. Even though not knowing is not an excuse, but it's better that once you became aware, even if it is delayed, you make them aware before the application goes. If the application goes before you tell them, the application will be refused.
Okay. Well, it does make sense anyway. So once you have anything to declare, please do that and do that in time. Yes, keep your questions coming through. We have Lawyer Charles Asma here. We're doing this courtesy BWF solicitors, and then we have the community at heart. So definitely we will be answering your questions. Somebody put this on our WhatsApp line and we picked that one up. It says, I entered illegally in the UK from 2004 to 2008. Voluntarily, I left. I applied for a UK visa in March 2025. Then in April, both times was refused and two times PAP, but each time refused on different grounds. But in the latest refusal, they refused on my ITR and illegal stay. First time they mentioned illegal stay, which I already disclosed in my visa application form. I knew my ITR are genuine and correct, but computation pages of IT are overlooked. The main thing I want to know is, do UK Home Office refuse solely on illegal stay? Is it possible? They accepted in my last refusal that I have strong financial and family tie. This one has a lot of technical jargons, and I believe that lawyer, with you break it down for us. So please help.
The person says ITR. I don't
Mhm.
know whether the person meant ILR.
I don't know. Because I
Yeah,
haven't heard
if they can come
ITR.
back. Is it, you mean the latest application was ILR? And they said because of your overstay, they cannot grant you ILR. Because I don't know what ITR is.
Oh, okay. The person you sent it to our WhatsApp line, please come back again with that. Thank you very much. Can we take another one? And when it is that we have further information, please, we will come back to your question. Get them through. If you would want to speak to us as well, you can call 0208 493 7345. This one says, it's from Esther and seeking your professional assistance with preparing and submitting a further leave to remain fee waiver application. And Esther would appreciate your advice on the information and documents that she requires and the service fee. Any help?
All right, Esther. So you're applying for a visa and you want to seek a waiver because you cannot afford. The bottom line is that you cannot afford. If you cannot afford, you have to prove that you cannot afford. How do you prove it? You say, what document do I have to show? You have to show that your income from all sources compared to your expenses, which are legitimate, are not enough to support your application fee. For example, you earn £2,000. You have to prove from all your bank accounts, your savings account, your ISA account, your current account. If you have different bank accounts, you have to bring from all the bank accounts. Then we can show that your salary gives you 2,000. You don't have any other income from anywhere. Your expenses is 1,900, and they are all legitimate. They cover your food, they cover your clothing, they cover your rent, they cover your telephone, they cover your subscription for gym membership, they cover the money you send to your family back in your country for their upkeep, they cover every necessary spending that you need to cover. If the difference is £100, which is the savings, then we can say that £100 is not enough. Because if you have to save £100, it will take you 40 months to save up to 4,000 for the application fee. And genuinely, you cannot afford. And on that basis, fee waiver will be granted. So that is how you have to show that you cannot afford the fee. And so they have to give you a waiver. A waiver application is a form. So you go on online, but because you said how much is your service fee, it tells me that you want a lawyer to do it for you. So I'm not going to point you to the visa application form. If you want us to do it for you, please get in touch. We'll assess your situation. Normally, when we come online, there's no obligation to tell public how much we charge. And so get in touch with us and we'll tell you how much we'll charge you depending on your specific circumstance. Sometimes we look at circumstance and say that this is our standard fee, but your situation is such that we have to be human enough to reduce it for you. We are interested in helping you to get your visa, not just the money. But again, we need the money to pay the bills so that we can keep the business going. So when you call us and we discuss and you genuinely need us to intervene for you, we'll intervene for you in a way that will be helpful for you and helpful for the business.
Well, thank you very much for that. Keep them coming through 2084937345 or keep them in the comment section down below. Nana Japoma Boachi says she's on a graduate route visa expiring next July and yet to get married to the British fiancé. What would you advise, lawyer?
Well, Nanama, all I'm saying is that if you want to switch from graduate visa to partner of a British citizen, we have discussed that today. That is all I will say. If you need specific advice on your matter because you've given us dates and the dates tend to be very tight, then it is your specific circumstance. So you call, seek specific advice to address your specific circumstance. But beyond what we have shared, there's nothing more to tell you. But please get in touch for one-to-one advice to address your peculiar need.
Good vibes, you are watching with us. Thank you very much. Emmanuel Selassie King, you're watching with us. Thank you. Thank you, Nanama. That's the answer. I would also continue to reiterate the advice that you seek one-to-one consultation with the lawyers and they'll help you. Now, I had a 3-year skilled worker visa. I've switched to another sponsor who's giving me a 3-year contract. I spent 3 years already in the UK. Would I be qualified for indefinite leave to remain when I've spent 5 years?
If it is the same industry, yes. But again, our friend who came with this question, the law is changing for skilled workers. I don't know the sort of skilled work you are on, but if you are on a low scale skilled work, where your salary is not up to 50,000 or 125,000 a year, then you are likely to be caught up in the 10 and 15-year wait that is coming up. We know the law is changing from September, October, November this year, which is autumn. And so if it turns out that skilled workers will have to wait longer than 5 years, then it doesn't really matter the answer we give you today. It will still change the dynamics. So my answer to you is that if nothing changes in the autumn regarding the new settlement timing, then you are fine. If the industry is the same, then it will continue. You don't have to restart.
Okay. Right. Thank you very much, Oversenders. That's your answer. Let's look at this one as well. Angela has a Ghanaian district court divorce certificate dated the 19th of May 2026. The certificate states that the ordinance marriage has been dissolved and that both parties are free to remarry. However, it also refers to the marriage having been customarily dissolved on the 23rd of May 2025. For UK skilled worker visa purposes, can this certificate be relied upon as proof of divorce, and which date should be recorded as the divorce date?
Okay, so I think it's all over the place. I don't think Angela followed the process to go required by law to get this done. You cannot have one certificate referring to different types of marriages.
Mhm.
Because for you to say customary marriage and ordinance marriage, you are referring to two types of marriage. So if the court that presided over the divorce proceedings knew what it was doing, they would not be making reference to ordinance and customary marriage at the same time in the divorce papers.
Mm.
So I don't know which court, but just make sure that the court is one that is recognized, not any other. I think our friend will have to get in touch, and because what I see here is a certificate that is issued wrongly, because the process in Ghana by divorce proceedings, I don't think they follow that properly. It's all over the place. So please get in touch as a matter of urgency. If I'm a caseworker and you bring this marriage a divorce certificate to me, I will question it. And if I'm your lawyer doing your application and you give it to me, I will tell you they have to go back and check again. And that is why I'm saying that please call and let's have one-to-one conversation. Because it tells me that something has gone wrong with the process of issuing the certificate.
Get it scrutinized and get it verified so you can get the right things done. Now, Daniel says that he came to the UK as a skilled worker partner for the past 3 years. Started a year course in the college only to discover the partner who is the main applicant has been sacked from the skilled worker job. He then told me he wants a divorce because he wants to marry another woman who is a British citizen. Can I apply for any sort of human rights, or can I make any sort of human rights application since I've just begun my college course, which does not qualify me for student visa? Or what is the best decision in this case for me? Somebody's asking for a lady friend. I get it now. Yes, sir.
Right. I mean, there's nothing for our friend. And I will say it as it has to be said. Because if you have just discovered that your main applicant has been sacked, are you telling me that you didn't know that your wife or your husband has been sacked? It doesn't make sense. Number two, if the person has been sacked, then your visa is at risk. What human rights application are you talking about if you don't qualify? One, you cannot apply under private life because you wouldn't meet paragraph PL 5.1A of Appendix Private Life because you haven't been in the UK for 20 years. Two, you cannot meet the requirement under paragraph PL 5.1B of Appendix Private Life because you don't have any issues that will prevent your survival in your country. Three, you don't have a wife or husband who is a qualifying partner, as we have discussed today. So you cannot even transfer from skilled worker dependent to a spouse of a British citizen under Appendix FM. And so simply asking, what can I do? You can't do anything if you don't qualify for all the things we have covered. Our friend needs full detailed advice, and please get in touch and discuss your case. And if you meet specific requirements, you look at what to do. Apart from that, you may have to consider to leave.
Well, we still have some time on our hands to pick up a question or two. We'll do that. And Nananye comes in. How can one determine whether a certificate of sponsorship is genuine or fake? I see that Good Vibes sent some comment on there. Send it to a lawyer for verification. Would that be the correct thing to do, lawyer?
If any lawyer tells you that I will be able to, they will be able to determine whether the certificate is genuine or not, they're only deceiving you. No lawyer has a way to determine whether sponsorship certificate is correct. Even the Home Office, the caseworkers have a database that will tell all the COSs that have been issued with their reference numbers. And that is why when they are assessing your application, they will say that we have assessed your COS against the database COSs. and we realize that there's no number that matches the ones that have been issued within the database, and so it's fake. Or the one you brought matches one that has already been used, and so it cannot be reused. Only caseworkers have that database to access. No lawyer, no lawyer, no lawyer can tell you that they can check. So your question is, how can we do it? The answer is, there's no way we can do it because we can never have a way of doing it.
Okay. Well, you get it as genuine as straight as it is. Trust BWF solicitors to help you genuinely in your situation. How long does it take for the court to ask for my bundle after filing an appeal?
Right. So within the first year tribunal procedure rules 2014,
Mm-hmm.
the law says that once an appeal has been filed, the Home Office has 28 days to file their evidence, and the appellant has 42 days to file evidence. So if you are the appellant, which is our friend asking this question, if you have filed your appeal, you can file your evidence within 42 days. Normally, the court will tell you that wait for us to request your evidence, which is the case building. There was one time I filed my evidence ahead of time. And the court said that, yes, we see that you have filed your evidence, but that is you just be rushing. It's too early. Wait, wait, wait. And I said, oh, these people, when we do it early, wait. When we do it late, why are you late? But the bottom line is, if it's ready, keep it. Once they ask for it, you file it to them.
All right. Um, I don't think we have time enough for any other. So I will quickly ask you to get me the answers to the scenario posed about Bob, who had been deported. He was convicted for such a sexual offense, sentenced and deported from the UK. He wants to come back to join the family. The wife is British, the child is British, but he has been refused entry to join the family. What can he do when or what would be the outcome if he appealed? Margaret Asante says, number two, the appeal will be dismissed because he did not meet the requirements for his application. We have Isaac Boateng saying that the appeal will be dismissed because human rights do not override public interest of executing, of a public interest of excluding serious offenders from the UK. Francis Kwame Usu also thinks it's number one. Thank you, Francis. The next one is from Linda Ojem. Linda Ojem also says the appeal will be dismissed because the human rights do not override public interests of excluding serious offenders from the UK. Ebenezer Kwesi Osafo thinks it's number four. The appeal will be allowed because he has never broken his deportation conditions. Rachel Asamoah thinks it's number one, where it says the appeal will be dismissed because human rights do not override public interest of exclusion. Kofi Anoche says the appeal will be allowed because he has a child and wife in the UK. Omar Gaigai says that the appeal will be dismissed because human rights do not override public interest of excluding serious offenders from the UK. Same things, Obapa Doki. Let's take one more and then we go to lawyer for the marking. Timothy Brobe says that the appeal will be dismissed because he did not meet the requirement for his application. Let us as well. Interesting answers there. Bob deported. He has his family in the UK. Both wife and child are British. But now they are saying because you were convicted of a sexual offense, you were sentenced and deported, we found you very risky to be here. So that's why we sent you away. And we still find you to be risky to the community, so we can't let you in. Bob's appeal, what will happen?
Okay. So let's look at the case law. The case law. If we
That's a
go
nugget.
back to
Yeah.
the nugget.
If we go to the nuggets, yeah.
So we are told that the case of no the nugget, yes. So please read that. What does the court say?
It says the court has confirmed that Article 8 family life rights do not automatically outweigh serious public protection concerns, where a tribunal finds continuing safeguarding risks. It must explain why those risks do not make exclusion conducive to the public good.
So even though Bob will say that I have a wife and child, even though Bob will say that I have met the requirement, Bob can put all the argument forward. But the bottom line is that because of the serious nature of the offense, he might even be on the sex offenders register, even though the fact did not mention that. But if it turns out that his absence from the UK is not enough to justify his admission, and simply getting married and having a child will also not justify his admission, then the court will always conclude that the caseworker who would grant the visa would have made a mistake. And so it's quite clear that because of the offense and how serious it is, the court will conclude that the offense, which is public good or interest nature, will have to be taken serious. And so his human right as a family or husband of this person, British person, and the father of this British child must give way in protecting the interests of the public so that other children, other people, other members of the community can be safeguarded, because this is a sex offender who is to be admitted back to the UK. The answer is one.
Then I would ask a follow-up question briefly. If this person has gone through rehabilitation, there have been some assessments to say that he does not pose that threat. Is there a remedy?
Obviously, if there is clear evidence to support the claim that it's been over the years, so timing is important to support rehabilitation. This person came to the UK. Do we have when the person came to the UK, for example?
Yeah, I was talking about, it didn't say when, but he was granted in 2024. It didn't really actually say, but I think it was earlier.
But we are told that the person was in the UK and was deported, right?
Yes.
Yeah, it says that the person was granted 5 years in 2024, welcome the child. Now, so if you are talking about EU, for example, or talking about skilled work, for example, this one is EU. So if it is EU, for example, then we know that EU started as far back as, let's say,
I think I found the year, because in line 3 it says after 2 years in the UK he was convicted. Then in 2024 they welcomed their baby. So I'm assuming that plus or minus it was 3 years before 2024.
yes. So you can see that somewhere 2021, right?
Mm-hmm.
So he came in happy, messed about, and got convicted, pre-settled, taken away, was deported. And whilst away, wife becomes pregnant, I want to come back, all within period of 4 or 5 years, right?
Yes.
Is this period enough to prove genuine rehabilitation? No.
No. Okay.
No. So what is genuine rehabilitation window? There's no time limit. However, the longer the better. Because you are proving that, look, I've been away for 10 years, I've been away for 8 years, I've been away for all this while. And since being away, I've never offended. And therefore, there's high chance that once I'm readmitted into the UK, I will continue to prove myself in that respect. There should be evidence from rehabilitation agencies, probation services, community involvement, and all that to support the rehabilitation claim. If the person was deported, then there should also be an application to revoke the deportation order that was made against them. So there's so much to do, not simply saying that I have a family, so I want to come back. If you have a family, to be fair, you and your family can also stay away from the UK and still enjoy your family life. So the key thing is, why should the person be readmitted if their behavior is not strong enough to suggest that they are a better person than before? They will not. And the court is clear. Where even this case, the first court made a mistake and allowed the appeal, and the second court made the right decision to overturn the allowed appeal in favor of the Home Office.
Okay. Well. Time and tide, they say, waits for no man, and we can never be exceptions to this golden rule. But before we go, tradition cannot be overlooked. So we will definitely briefly ask Lawyer Asma to give us a snapshot of what we discussed this afternoon, step-by-step process for switching from one to the other. Lawyer Asma.
Thank you very much. Thank you. So you can see, because of the community engagement everywhere, we are far away from where we usually be sitting. But it's still necessary that in the best interest of the community, we have to avail ourselves wherever we find ourselves. So we are far away up north, but we thank God that we still manage to engage and to share the learning. Now, today, what we have learned is that if you're a skilled worker, men, or skilled worker dependent, you can switch to another visa category under Appendix FM as a spouse of a British citizen, or as a spouse of somebody with indefinite leave to remain, or as a spouse of an EU national with 5 years or indefinite in the UK. You have to show that before you made your application, your visa had not expired. You have to show that your partner has one of the things we have mentioned: British citizenship, indefinite leave to remain, or EU nationality with status. You have to show that the relationship is genuine and subsisting, all the evidence necessary. You have to show that the English language is met A2, and you have to show that there is income threshold met for 29,000 before tax a year, combined for both of you or from one of you. All you need is the 29,000 before tax. If the person is self-employed, or your partner is self-employed, the sponsor is self-employed, they have to show 29,000 profit before tax from self-employed business activities. This is the conversation we've had for today. And we'll continue to enjoy the rest of the weekend. Thank you.
Thank you very much. And as Lawyer Asma mentioned, the community engagement takes them a lot out of town and most of the time as well. But he has found some time and, of course, giving us the opportunity to learn what it is that we learned today. So join me to say thank you to Lawyer Charles Asma. He's still in the birthday celebrations, and we wish you all the best. The prayer we said we want to repeat: may God enhance your cause. Thank you, Lawyer Asma.
And Brakoku, I think on that note, I also want to say thank you to the BWF Sisters family, from the senior partner, Uncle Ben himself, to all my colleague staff at the office. Thank you for your messages of goodwill. Again, our multitude of clients, messages were pouring in from left and right. We say thank you so much. My followers on TikTok, on Facebook, everywhere, we say thank you so much. all my clients or our clients, thank you so much. And of course, our well wishers across board, we say thank you and may our God bless us always.
And on that note, I don't need to say more. We want to say thank you very much for your time this afternoon. And your questions and your contributions are very much appreciated. What I want to say is that we have another edition coming up same time next week on the program The Community and the Law on BWTV. I work together with Pablo Dudu Shilankra. I'm a producer, Professor Adair. My name is Oreku Fripon. Have a good evening.